Look, you don't hurt a child.
So,
You don't harm a child on my watch without going to jail. You go to jail.
so,
You're going to go to jail as a condition of your probation. I'm just finding out how much you've served in jail already. You're going to go to jail. You can't do this. I'll place you on deferred probation, but I can sentence you up to 180 days as a condition of probation.
You want to tell the judge anything?
I'm raising mine. Can I get another little time?
What did she say? What did he say? I didn't understand him. He mumbled.
Tell the judge again.
Man said, man, look, man. I'm gonna go ahead with what he said, man. I'm not gonna gotta talk to the judge, man.
All right, we're good. He's competent to stand trial. He's brought back.
Okay.
We'll see him at a hearing in 4 weeks. We'll have a hearing.
Told you I want to talk to you, man. Come on. Over with, man. Told you that already, man.
Hey,
You can't comprehend with
be polite to this man. Do you understand? All right, then. Oh.
Completed probation.
A plea of probation. We need a bailiff, just for a second.
I need Mr. Haddock's thumbprint.
Oh, we need a thumbprint.
His thumbprint?
Yeah. Just one. All right, 22-39370 is now called the State of Texas versus Theodore Joseph Jagno. That's you, sir? You have to speak out so she can hear. Okay, thank you.
This is.
And you're here with Mr.
You'll need
Radford, your attorney, and the state's attorney.
It's that case that indecency to a child, F-22, is going to be dismissed. There's a new indictment. I don't know if do we have the jacket on the new indictment?
No, I do not have the new jacket yet.
Okay,
All I have is the old one.
What is it?
so we need to endangering a child. I need to print off the indictment I get.
Wait. I've got two different cases on it, two indecencies.
Have you got the F-24?
Did I pull it?
Shouldn't be two indecencies, should just be.
Yeah, there were two.
Yeah, 22-39370 and 22-39371.
Okay,
Oh,
that's right.
Those are to be dismissed?
Yes.
Those two?
Yes, sir. There's a new indictment.
Okay.
No, I didn't have that yet.
Do you have the indictment?
I'm gonna print it for you, sir.
I do have an indictment handed up on October 30th of 2024. And 24 CR 2264 alleging and contending that Theodore Joseph Jagno committed the state jail felony of abandoning or endangering a child. This was alleged on or about November 13th, 2021 in Jefferson County, Texas. 3 years ago, nothing like us staying up to speed. We're just, it's a shame that anything so delay so long, but it's the way things are.
So that's why.
It says
I dismissed.
intentionally, knowingly, recklessly, or with criminal negligence engaged in conduct that placed a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. And by becoming, and that word doesn't even exist in the English language, intoxicated.
Oh, sorry, Judge. I moved to correct that to intoxicated. No objections.
And by becoming intoxicated, we will change that. It's obvious that
Yes, sir.
that was misspelled. It meant to be intoxicated. There's just a C missing there. And attempting to assault the child by throwing objects at the child, grabbing the child with his hands, and did not voluntarily deliver the child to a designated emergency infant care provider as provided under the Texas Family Codes. The eighth line of the body of the allegation in this indictment. There's a word in intoxiated, which all parties contend and agree is misspelled and it should be intoxicated. I'm going to change that to correct it without objection.
No, sir.
Okay, that has been corrected. It says it supersedes or is re-indicted from 22-39370. Thing that I don't see anywhere is the age of the child in any of these probable cause of affidavits. They keep saying
she's
the
about
child's
13.
under
She's a
17.
teenager.
She'll be 14 or 30 next month.
So she's about 12 at the time of this happened.
This happened,
Just-
wait, this happened November
12, yes, sir.
13th of 21, so that's 3 years ago.
About 11, pretty close to 11 or 12. Yeah.
All right. In the agreement here, the plan is to place the defendant on deferred or unadjudicated probation, dismiss. It just has one case. We've got it.
Yes, so the other one was already dismissed. I re-indicted it. When I re-indict one, it only brings up the one case that we re-indicted it for. So I already dismissed one case.
Okay.
So the 7-1 case has to be dismissed this
Okay.
time.
Seven's,
It's previous.
it says 39370 and then 39371.
Yes, 39370 was already dismissed.
I just kept the files together when I
Yeah.
told them, Judge. Didn't want to confuse.
Okay. Okay. That's unusual because they're in numerical sequence,
Yes, sir.
but you didn't dismiss it.
No,
at
sir.
the
When,
time of the indictment.
no, sir,
later
because
on.
I needed to have the leverage of the other case in
Okay.
case the plea
So-
went bad. So
We're showing
Yeah.
that 39370 is no longer active, correct?
Yes.
Correct.
Because, okay. Because there's only one case and that's the plan.
yes, sir.
And, all right. Thus, the defendant waive a formal reading of this indictment and arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about November 13th, 2021, in Jefferson County, Texas, you committed the state jail felony of abandoning or endangering a child. And again, the crime under section 22.041 you are alleged to have committed is abandoning or endangering a child. Do you understand what you're charged with here, sir?
Yes.
Again, in summary, this alleges that on or about November 13th, 2021 in Jefferson County, Texas, you intentionally, knowingly, recklessly, or with criminal negligence engaged in conduct which placed a child younger than 15 in imminent danger of death, bodily injury, or physical or mental impairment. And this states by becoming intoxicated and you attempted to assault the child by throwing objects at the child and grabbing her with your hands. And you did not deliver the child to a designated emergency infant care provider under them.
That other one's kind of superfluous, but it's the state jail is the way it's.
You understand what you're charged with here?
Yes.
All right, a state jail felony carries with it, sir. If convicted, you are facing a term of not less than 180 days or more than 2 years in the state jail. In addition, a fine can be assessed not to exceed $10,000. Do you understand?
Yeah.
An agreement's been reached here where you would be pleading guilty and placed on deferred or unadjudicated probation for up to 5 years in length, and cause number 39371 would be dismissed. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this indictment charging you with this state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yeah.
Yes.
Yes.
State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Anything else to add?
No, sir. We've made a PSI.
How much time does he have credit for in this case? Were you in jail for a while?
Huh?
Were you in jail for a while? For how long?
2.5 months.
You know, PSI is waived. That's, look, you don't hurt a child.
So,
You don't harm a child on my watch without going to jail. You go to jail.
so,
You're going to go to jail as a condition of your probation. I'm just finding out how much you've served in jail already. You're going to go to jail. You can't do this. I'll place you on deferred probation, but I can sentence you up to 180 days as a condition of probation. When you hurt a child, you go to jail. Do you understand? That's the rule for me.
yes, sir.
Judge, if I may.
That's the rule. I'm reading the probable cause affidavits. These are terrible. You did a terrible thing for that child. And you're lucky your attorney has been able to fashion a wonderful deal for you because what you were charged with was more serious, but it's the probable cause affidavits that I'm reading. The probable cause affidavits are terrible.
Yes, sir. I understand.
You can't hurt a child like that, intoxicated or not. When you're voluntarily intoxicated, you're responsible for your conduct.
Yes, sir.
Yes,
78 days.
you're going to go to jail for 90 days. Or do you work somewhere? Are you employed?
He's disabled.
You're going to go to jail for 90 days. I can sentence you up to 180 days. I'm going to give you credit for that. But you're going to go do 3 months in the county jail as a condition of your probation.
That as a condition of probation.
You understand?
Okay. I have to do that about
It's,
that.
sir,
So like you said, I'm.
sir, how do you unhurt a child?
Sir?
How do you unhurt a child? If you've hurt a child, how do you
No,
undo
there's
it?
no way to.
Well, then you're responsible that you have to pay a price. A condition of probation will be you will serve 90 days in the county jail. There will be other terms and conditions of probation as you are placed on deferred or unadjudicated probation for 5 years. And these will be essentially terms and conditions of probation, which are normal and customary. What is there any type of program that we have for this type of offense? I mean, there is, it's a child.
Since alcohol was involved. with
What's
this,
moral recognition therapy? Oh,
we do that
let's
also.
do that. I see that a lot, and that's for a variety of things, and it seems to be a good general program. For cases where what is your criminal history? I don't know of anything. Have you ever been convicted of a crime before, sir?
I've done like 70 something days whenever they put me in for this. Yes, sir.
Let me just, well, once again, I don't feel sorry for you.
Yes, sir, I understand you. Yes, sir.
How long do you think that child will remember? How long do you think that will haunt that child? How about the rest of her life?
Yes, sir. I understand perfectly.
All right. You can't harm a child without paying a price on my watch. That's just the way it is. It's just not morally and legally right. You've got to avoid ever doing something like that again. You understand?
Yes, sir, I understand. perfectly. Yes, sir.
You're treated, we're gonna treat you.
I know I did wrong when I was drinking that bottle.
Okay. Well, you know what can cause it. Be careful on that. And voluntary intoxication is not a defense under law. Okay. Please see the probation officer. When can,
He needs to be printed.
you need to report, I'm gonna give you a few days to take care of business. You need to report on or before 6:00 PM Friday at the county jail. Do you understand?
Okay,
On or before 6:00. That gives you a few days to take care of whatever business you need to take care of before you start your 90 days.
okay. Fine.
All right.
Thank you, sir.
Thanks, Tom. And please see the probation officer.